All right, good afternoon. My name is Don Nguyen. I'm a Florida bar licensed attorney specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with a case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you are sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information may be displayed on the screens and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are any objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. At this time, I'll swear in all witnesses. If you intend to testify for your case, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You guys may all be seated. I have received and I've already gone ahead and reviewed the July 14, 2025 minutes. Everything appears to be in order, so we'll go ahead and deem them to be approved. We'll move on to the hearings. I'm going to do things a little bit out of order today, so I want to go ahead and first, are any of the parties here represented by counsel? Yes. All right. I'm going to go ahead and take you first so that you guys can, stop the clock running on those hourly fees. So this is case 25-48.
Hi, my name is Khadijah Sullivan. I represent Pop Florida Properties LLC in this matter, and we've been trying to work with the tenant to go ahead and get the violation fixed. If you want, I have copies of the quotes that we've gotten sent in.
Let me let the city go first, if you don't mind, and then you can respond, and then anything else you want to provide, you're more than welcome to do so. But yeah, I don't know anything about the case yet, so.
Good afternoon. I have 3 exhibits to submit. The first one is the affidavit and notice of hearing. The second is the affidavit and notice of violation. And the third is our cost recovery statement in the amount of $216.58.
Thank you.
So once again, this is the initial hearing for case number 25-48. Our respondent, Pop Florida Properties, LLC, and our registered agent is Corporate Creations Network, Inc. The violation address, 3675 Cheney Highway, Titusville, Florida. And we have 2 mailing addresses, 4515 Lyndon B. Johnson Freeway, Dallas, Texas, and 801 US Highway 1 in North Palm Beach, Florida. We have 1 violation this afternoon. It's 30-305. This is continued maintenance required for landscaping. So the initial inspection was completed on November 14th, 2024. A copy of the notice of violation was hand-delivered to employees on property. They were given till January 14th, 2025 to come into compliance. We have proper service on both the notice of violation and the notice of hearing. So a complaint was received from Titusville Development Services concerning the required landscaping not being maintained on the commercial property. I received a copy of the approved landscape plan and completed an inspection of the property. We had multiple missing plants within the vegetation and landscape areas. Pictures were taken and the notice of violation was hand-delivered to the manager on duty. So I've had multiple on-site visits with 2 different district managers, the store manager on multiple occasions, and a landscape contractor to discuss the ordinance, review the landscape plan, as well as discuss the irrigation system. As of an inspection done this morning, we don't have any work started to replace the missing violation, or vegetation, sorry. So this is a bird's eye view of the property. And this is just a portion of the approved landscape plan, just outlining what's supposed to be on the site, a combination of ground vegetation, bushes, and trees. So these are all pictures taken July 29th, 2025, when I was posting the notice of hearing. There's very few plants around the exterior of the building, the restaurant itself, and then all the vegetation that's supposed to be along the edge of the parking lot is missing. So again, the conclusions of facts in this case, for section 30-305, the property is missing plants as required by the approved landscape plan. So we are requesting an order be issued to correct the violation on or before noon of September 5th, 2025. To come into compliance, we are asking that plants are installed to meet the requirements of the approved landscape plan. If the respondent does not comply by September 5th.
Is there something wrong with the irrigation system as well?
The irrigation system, it's on the reclaimed water system. On one of my visits there, the irrigation system was just spraying water straight out of a couple of missing heads, so they had shut the irrigation system down. I was out to the property last Friday on the 8th. A contractor was on site working on the irrigation. I have not seen it functioning, but they were working on the irrigation.
But that is part of the repairs that they need to do, right?
It is.
Okay.
To
Yeah.
maintain the health of the plants, the
Okay.
irrigation system needs to be functional.
Okay.
So requesting a fine in the amount of $100 per day per violation be issued, and requesting administrative costs be assessed in the amount of $216.58. Once all the corrections are made, to contact myself for a reinspection.
Sounds good. Thank you. Ms. Sullivan? It's Ms. Sullivan, right? Okay. The addresses that we've been, or that the city has been mailing the notices to, are those the correct addresses for the company? Okay. All right. So you represent Pop Florida Properties,
Yes.
right? Okay, not the
Not
tenant.
the tenant, no.
Okay.
So we have been in contact with tenant per our leasing agreement. It is their responsibility, but we understand that as the owners, it falls on us. But we have quotes, if you would like them, to do with the irrigation system, as well as pictures and quotes for the plants that we need. Because we are in the process of getting it done, but it couldn't be done by today. But we are in the process of being in compliance with the violations, and we were just hoping for a 30-day extension to get everything done.
The city is requesting that it be done by September 5th. Do you anticipate it being done by that point? It's not quite 30 days, but it's like 25.
We hope so. But yeah, we're in contact with them. They have the quotes, and the quotes are good for 15 days, so I'm assuming within that time.
Is this one of those things where you would have to, as the landlord, come out of pocket and then charge it to them? Or are they going to hire the contractors
So
directly?
they have hired the contractors.
They have?
Yes.
Okay. I feel like September 5th is enough time then.
Okay.
Is there anything else? Or, let me see the quotes, by the way, sorry. You brought them, so I'll take a look. Thanks. So the tenant has already signed the estimates or accepted the estimates, I
Yes,
said?
sent us the
Okay.
estimates.
I don't know nothing about landscaping. Is this everything that needs to be done? Anyway.
The only thing that I would need to double check on is the jasmine as a replacement for the winter creeper, but
Okay.
we can check with Development Services before she leaves today.
Okay, perfect. All right. Well, okay, I'm ready to make a ruling unless there's anything else you want to add.
That's fine.
Okay. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent, Pop Florida Properties LLC, is the owner of the property with the address 3675 Cheney Highway, Titusville, Florida, 32780. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on evidence presented, I find that violations of Section 30-305 of the City Code, which requires continuing maintenance, exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but either failed or refused to do so. The corrective actions for these violations shall be to install new plants to meet the requirements of the approved landscape plan and complete the repairs to the irrigation system. Additionally, I find that the city has incurred costs in the amount of $216.58. Such amounts shall be included with this order. Respondents shall be given until noon on September 5th, 2025 to correct the violations. Respondents shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by noon on September 5th, 2025, a fine will be entered in the amount of $100 per day until the violation comes into compliance. Any further and future violations of the same sections shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you. Keep those billing entries low. All right. We'll get back onto our agenda in order then. I think there was no, we're moving right on to the lien reduction hearing. So the first one is item B1 on the agenda, which is for Sky Investments. There's no case number I see here. Okay. 4B1 is what I have. All right. Are you here for that? Yes. Yes, you may come up. Officer Flanagan, you may proceed.
Wait, there we go. Again, this is for Sky Investments. The address, current owner address is 200 Cheney Avenue. This is for 195 Roosevelt Street in Titusville, Florida. And the original charges were for the dead trees on the property. This one was kind of got confusing. On March 11, 2025, at the regular city council meeting, the staff presented the request for the reduction, and the owner, who was present at the meeting, after reviewing the request and hearing testimony of Mr. Myers, the code enforcement recommended the reduction of fine to $0 and the city cost the amount of $216.58 must be paid within 90 days, or it would go back to the original amount of $13,100. On June 10th, Code Enforcement Department verified that the 90 days had expired and the city cost of $216 had not been paid. Additionally, it was found that the property had been sold to a new owner, Sky Investments, on March 6th prior to the city council meeting to request. So Mr. Myers at the time didn't have standing to request a lien reduction on something he didn't own, basically.
He had already sold it by that date?
He had already sold it, yeah. On June 18th, 2025, the legal department sent a demand letter for payment and was in default of the city approved for the reduction of the lien. On June 25th, Code Enforcement received an application as well for a lien reduction from the new owner, Sky Investments. And on July 23rd, 2025, received an email from Sky Investments that they would be present for the hearing. And they also, Sky Investments, who requested the lien reduction, is also deeded the property over to Athens LLC, which my understanding is the same owner, just different corporate name. And I don't know if you need the gist of it. It's basically $13,100, and they're requesting the reduction of the lien, again, under the new ownership name. And this is the original picture of all the debris that was on the property and the dead trees. And that's just another overall picture of it. Oh, I'm sorry, that's the cleanup of the lot, and since that picture was taken, there's a newer picture that he did do a lot better job of clearing the lot and different underbrush of the trees and stuff. So it does look in good condition.
Was a condition like that prior to this? Oh, yes, this is February, okay. So,
Yeah, that was back in February, but since that picture, I thought I put a more current picture in there, but I didn't. But he's cleaned out more underbrush and stuff, and all the dead trees and everything's gone, so it does look good.
by
It
he,
is
you
in
mean this
compliance.
gentleman here?
Yep.
Okay.
Yep. I assume he did it. I don't know. Someone did it.
All right. Sir?
Hi.
And what is your
Yes.
name?
Vern Daniels?
Vern Daniels. All right. Make sure. Sorry. And do we have the correct address for you? It's 195. Well, that's the property address. Do we have the correct mailing address for you?
2000 Cheney Highway, Suite 103-170, Titusville, Florida 32780.
Glenn, do you have that? All right, cool. All right. Vern, what do you have for me?
I'm just the new owner. I had no idea that this was going on. I just cleaned up the property on my own, and I found out about it later. I wanted to switch one thing from one LLC to the other, but I just want to make sure that I'm very compliant to the city, and I don't want to be in the middle of any violations. So I take good care of that property. There's nothing on it, but I make sure that I go by and clean it up all the time.
This never came up at all during your entire title and escrow process? Because I see you, you went through a title company.
No, I didn't. I didn't know anything about it. I just wanted to hurry up, clean it up, and I pretty much brought it down to sand.
Do you know if a municipal lien search was ordered at the time that you closed?
No, I was just totally. I wasn't aware. I just trusted the system, and I just wanted to clean it up. If I would have known that, I think it came out to like $200 something, something like that, I would have been more than happy to pay it.
It's interesting because I remember this case because I was the one that rejected their first lien reduction request. They weren't present at the time, but I remember looking at the files like I don't see a basis for reducing the lien. And so it's surprising to see that the city council saw fit otherwise to reduce it to zero, which kind of leads us to this predicament that we're in. And I don't think that's your fault. But I also don't think that it's, again, I didn't see the basis for the reduction of the lien in the first place. But that has nothing to do with you because the lien was imposed on your predecessor. And I believe everything you're saying as far as, how you came to find out about it and everything. I'm surprised this never came up at all during your closing because it looks like you went through a pretty reputable title company.
Yes.
You have title insurance. But actually, no, the lien was never, our lien was recorded, right, Glenn? No, our lien wasn't recorded, okay.
No, we never received a request for lien check on that property.
Give me a second, let me look at all the factors that we have here. How much did you purchase the property for?
$30,000.
I I honestly feel that during the closing process, there are certain seller's affidavits and everything that you receive that the seller has to disclose to you, anything that they know that may affect or impact the property. And, either it was disclosed and you didn't read it just because you received a mountain of paperwork, or they didn't disclose it at all. I would definitely suggest you take a look back at some of those things. Because I'm not going to reduce it to zero. I'm going to reduce it some. But I don't think that the factors justify reducing it all the way to zero. And I know, again, I'm not going to question what the city council did, but I'm surprised that they granted such a reduction on a case where I didn't see where the factors really justified that. Is there anything else you want me to take into consideration before I make a ruling?
No, it's just it took me like at least a month to clean it up. I spent about, I would say about what the lien is. I spent that much, a little bit over that to clean it up. It was a mess. It was a huge,
No, and I believe everything you're saying.
Yeah.
I really do.
I just had no idea that I was thrown into such, I was thrown into the fire and I had no idea.
I'm not
So
saying that
it was
you
a
may
rookie
have a
mistake,
claim
I
against
guess.
anyone else that was,
Yeah.
on the other side of that transaction. It should have been brought up to you. That's,
I apologize for not knowing I don't know. I trusted the system.
Officer Flanagan, do you have anything else you want to add, or?
No, like I said, when it first came to you, he was made aware, the original owner, Mr. Myers, was made aware. He
Yeah.
didn't show up for the hearing, but he did show up for the council meeting for the lien reduction request, so.
I still don't understand why. All right.
I'm with you. The only thing I can say for Sky Investments is once the property did change hands and they took it over, they did immediately start
No,
cleaning
I
up the
understand,
lines,
and
so.
everything that
Yeah,
Mr. Daniels is saying, I fully believe, and, yeah. Go.
I just don't understand. I guess I do need to speak to Mr. Myers, but if it was reduced to zero, why wouldn't he tell me? Why?
I don't,
why
well, it
take
wasn't
this-
reduced, it was reduced
Oh,
to zero, and then $216 for the
Even
costs.
216. Why not tell me?
I don't know.
What would go through?
Well,
someone's
actually,
mind to do
that hearing where they agreed to reduce the lien was after he had already sold it to you. So he shouldn't even been at that meeting speaking on behalf of the property. He had no authority to speak on the behalf of the property owner, which at that time was you, not him.
Gosh. Okay.
So actually, at the time he sold it to you, he was well aware that there was a $13,000 lien on the property. And then maybe he told you, hey, I'll get it taken care of by the city. You don't have to worry about it. I don't know.
And this is from trees, bush.
Dead trees and overgrowth on the property.
My gosh, why would he?
It's just $100 per day, so it keeps stacking up, and you have however many months he had to fix it, because it was under the other special magistrate before I got involved. That's how long it had been going on, which is why it accrued to that point. But again,
Okay.
it should not have been reduced because he was not the owner at the time. It was you, which, I mean, is good because now you're here, but either way, you're living with the consequence of it, so,
Yes.
yeah.
Yes.
Glenn, did you have anything?
Oh, no, sir.
Okay.
Just in case you had any further question.
All right, I'm ready to make a ruling. I've reviewed the lien reduction application and the city code provision that is applicable and have considered documentary evidence, including photos and sworn testimony relating to this matter from city staff and respondent. I will recommend that city council reduce this lien to $1,000 based on several factors as provided by the city code, including the gravity of the violation, the actions taken by the applicant to correct and time it took to bring into compliance, the accrued amount of the lien compared to the market value, how you came about to know about the lien and the violation. I think those are all mitigating circumstances to justify a reduction, a considerable reduction. In addition to the lien amount of $1,000, the lien will include all costs incurred by the city in the amount of $216.58. It is so ordered. You will receive a written order from today's hearing, which will just be a recommendation to City Council. You will have notice and opportunity to attend the City Council meeting where the recommendation will be considered. So, again, as long as you still own the property, you can talk to City Council about it. But
Can I just real quick, can I just request that Athens LLC is included on that order, because he changed it over to Athens LLC.
oh, the title's already changed to Athens
Yeah.
LLC.
Yeah,
Okay, all right.
but it's the same, that way there's
So
another.
should we refer to the applicant, well, we'll refer to the applicant as Athens LLC, as successor to, or whatever.
Sky,
Yeah, to Sky Investment.
Good question. Where do I go to pay it?
You can talk to these gentlemen here.
Oh, I'm sorry.
When they start the next day, so I'll let you know.
Okay.
Just give him a minute. We'll start the next one. You can explain it in a second.
All right, thank you.
I'd say it gets easier, but it doesn't, the next one.
All right, the second item on the agenda is 508 Lucky Street.
Okay. The current owner applicant is Bianca Bland. I don't believe anyone's here for that case. Their current address is 3690 Buttonwood Drive. and it's 508 Lucky Street. Since, I don't know what you want to do, this is a lien reduction and they're not here, if you want to continue, or do you want to? You want me to?
We'll go over all the notices and stuff like that, and we'll go ahead and hear it now. I mean,
Well, they're the ones that were aware of the hearing. They were notified of it. They requested this date. This case actually started back in 2007 when the owner, Daisy Mitchell, didn't respond to the meeting apparently, according to the notes, was given until September 5th to correct the violation. The fines at the time were $25 a day, and the administrative cost of $384.32. It was for, I'll give you the cliff notes because there's a lot of writing on here. It's junk and debris, overgrowth. And then in 2019, there was another code hearing for dangerous structure and junk and debris. And at the time, there was a different owner of the property. On May 13th, the fines were started at $150 per day for the violations, and administrative costs were imposed. And on July 23rd, at the regular city council meeting, item 9D authorized the demolition of the structure located on 508 Lucky Street, and that was taken care of. The total daily fines accrued is $154,000, and the city cost of $4,000, for a total fine of $159,151, and the applicant was requesting a reduction of $155,500, which would have been minus the city costs. And on May 30th, we did receive the applicants for a lien reduction, and on July 25th, Mr. Bursch acknowledged the receipt of notice of hearing for today. Those are just the quick facts. These are the before pictures before they demoed the house. That's what it looked like after they demoed the house, and that's the current status of it today. So it's definitely no violations on the property as of today, but, and again, the applicant's not here to state anything.
all right. Did you give me the mailing affidavits and everything, or no?
No, they don't.
I think it's in the packet that you gave me. I couldn't bring it up, sorry.
Typically, it's in these hearings are at their request.
Oh, I got you. Yeah, right. Okay.
That's when we verify the receipt of today's hearings.
So they did acknowledge the receipt of the notice of hearing, I see, on July 25th.
Yes, and Mr. Burse acknowledged on July 25th, he called me himself,
Who is Mr. Burse in relation to Mrs. Blaine?
her husband
Okay.
and business partner.
Well, the basis that they were claiming, I guess, for their reduction application was that I guess they took it on from a prior owner, but I was looking at some of the deeds that you sent me. It just looks like they've been deeding it back and forth between family members. At least they have the same last name. Is that
Yes,
correct?
that is correct. for
That's
several years,
correct,
yeah.
sir. At least, top of my head, I would say 4 different occasions they've changed ownership to each other.
Yeah. You know how I feel about that. I don't think you can bury your head in the sand and claim you didn't know, accept quitclaim deeds and send quitclaim deeds and then get waivers of what you owe the city because you say you didn't know. So I'm not a fan of that. But, well, since they're not here to bring up any other factors or anything, I guess there's nothing else I can really consider as far as their lien reduction application. So I guess this will go before the city council for recommendation then. I have reviewed the lien reduction application in the city code provision as applicable and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff and respondent. I will recommend that city council not reduce this lien as none of the factors set forth in the lien reduction application justify a reduction of the lien, and the respondent was not present to bring up any other mitigating circumstances. Therefore, the lien stands. It's so ordered. We'll send a written order from today's hearing, which will be a recommendation to city council. The applicant will have a notice and opportunity to attend the city council meeting where the recommendation will be considered. All right. The next one is 1229 First Avenue.
And the registered agent is present today.
Hello, sir.
Before we get started, sir, this property was a tax deed sale.
Okay.
And with that, there was excess funds of $9,833.82 retained, I guess, by the clerk's office.
How much was that?
$9,833.82.
Okay.
And they had 120 days for claims to come in to see how that would be dispersed. That time has not passed.
Okay.
It'll be September 5th. But with that being said, on this particular property, there's $28,179.39. And I just got this after the agenda. I'm going to present this to you, sir.
Okay, all right. I was like, you had me write down a lot of numbers.
And there's an additional stormwater lien in the amount of $2,072.55.
Okay.
For a total of $30,249.94.
Thank you.
So with that, with the
Are
outstanding.
these, I'm sorry. Oh, okay, so those are all added in together. I see. Okay, sorry.
Yeah, yes, sir. So with that, we can either, which would make it ineligible actually for a lien reduction. However, we can go ahead and hear it just as long as the registered agent knows that that $30,249.94 and the $5,874.87, which is our hard cost, would have to be paid within the 90 days before the lien reduction.
So regardless of the fines on there, that 30,000 plus
The fi-
5,000 in cost is going to remain anyway.
Right, it's not negotiable for a lien reduction.
Do you understand that, sir? Yes, I do. Okay, all right.
I just wanted that to come to the forefront.
Okay, understood. All right. All right. Are you presenting, Glenn, or Officer Flanagan? That's okay.
Again, this is 1229 First Avenue. It was for junk and debris and overgrowth at the time. This case was originally heard on August 11, 2008. It was owned by William and M. Sanchez residential lot. They were given until September 5th to correct it. Violations, the amount of $100 per day, started on September 5th and continued. An administrative cost of $394 was also imposed. The fines, like I said, the fines continued from the 08 case. On May 9th, 2016, a Massey hearing testimony presented by the city with overgrowth, unsafe structure. I believe there was debris on there, and there was fines were $100 per day starting on that one as well. On April 8th, 2016, and on July 23rd, 2019, at the council meeting again, they authorized the demolition of the structure that was on 1229 First Avenue, and the structure was removed on February 25th, 2020. The total daily fines, all added together, came up to $1,109,100, and the city cost of, I had $5,874, but I believe, has that changed, or is that addition to what you have?
That would be, the 5,874.87 is the lien amount for code enforcement liens only. The 30,249.
Yeah. We're just talking about the costs.
This is just talking about, in this PowerPoint is just our cost.
Okay. Yeah.
So it would be a total of $1,114,974 for the total. That's just the conclusion and the daily fines, the city costs and everything. And he's requesting a lien reduction of $1,109,000. But we also have the city costs of $5,874,000 to deal with. This is the before pictures, the structure that was on the property. Two pictures that were on there. This is them after they demoed the property. And there's nothing on the property today other than several times we've had to cut the grass cut and leaned the property for the grass cuttings. A little confusing, but yeah. What's that?
All right. Sir, I had your name, Mr. Da Silva?
Yes.
Is that correct? How are you today?
I'm good, and you, sir?
Not too bad, not too bad. Okay.
I'm
What can you
representing
tell
the
me?
prices for you. We got the property tax lien, tax deeds, and we did our due diligence, but we went to public records from the county, from the city, and we didn't find those code enforcements, to be honest. Then, when we receive all those papers saying the amount, we try to find harder. Looks like there is a third-party company taking care of the code enforcements. That's why we didn't see those amounts. But we have a project. We are a small business in the area. That was going to be our first project. And we have a partnership with a local builder to build a affordable house for that lot, you know. And we try to negotiate a amount that's about the
1.3
value-
million.
The value of that's way greater than, like, if I work my entire life, probably I'm not going to put that money together, honestly. And
Sorry, sorry to interrupt you, but you said there was a third party handling the code
Yes.
enforcement? What are you referring to?
because usually when we go to the tax deed action, we find the code enforcement liens on public records from the county or the city.
Did you do your search manually, or did you actually request a title
That's
commitment or
what
a
we
title
usually
report
do.
from a third party? Huh?
Unfortunately, here in Titusville, we did over the Brevard County and also the Titusville city, and we didn't find them. You know, looks like there's a third-party company can provide those informations. That's my first time with Titusville, so I cannot tell with like so well. But like I said, my goal is get lots, build affordable homes, and try to put on the market as soon as possible to make the place better livable and things like that.
Right, because, you know, I've represented several investors who purchase properties from tax deeds auctions, and I always tell them, make sure they're ordering a title, an ownership and encumbrance report, or a title report, title commitment from a title company, just to avoid stuff like this. And I'm looking here, and it was recorded in Brevard County against the former owner's name. That being said, the former owner does have a very common name, so maybe, you know, the search individually would have been harder. Again, I just bring that up just because, again, I don't like lack of knowledge in and of itself wouldn't be a determining factor, because I think you could have found out about it. Now, that being said, I do think that this is ripe for being reduced just because of the sheer amount of it. How big is the lot?
If I'm not wrong, that's 70,000 square feet.
77. How many homes are you looking to build on there?
One.
Just one?
Yeah, just one. And there's a builder, a local builder. He already built a few houses in the area. And we already have the project, 2 or 3 bedrooms, just depend what's approved. And we want to move forward. Their name is Pro Restore Services. And, you know, that's my first in the area.
What is the market value of a home on that lot in that area? What would that be?
The
range-wise?
lot itself.
If it was
something around
built out.
25.
If it was built out with a home itself.
250, 270, probably.
When did the violations actually get fixed? Do you gentlemen recall? It must have been a long time ago, right?
Yes, sir, we did that demolition, I want to say, in 2017.
Okay.
Also, since we got these lots, sir, we already did a cleanup in the whole lot. I have a landscape already taken care of, so we don't have more violations, you know. And like I said, it's not a lack of knowledge, but probably I skipped something, and, you know, we are human beings sometimes.
I get it. I saw in your application you had listed out a proposed resolution.
Yes. Why?
Do you want to describe what how
Yes,
that resolution is?
I proposed
I don't
that
know. If
sorry.
yeah.
I proposed that because I noticed you guys had cost for clean the lot, for the demolition, and I noticed you guys had costs for it, and I want to pay for it, but I cannot get all the fines, all the fees and everything, because that's going to be way beyond the lot cost, you know, and we're not going to be able to do anything, honestly.
Right. So you heard what Officer Tolleson, Glenn Tolleson here said. The utility services and the stormwater liens are not subject to any reduction today. So those are $28,177.39, and then $2,072.55. Then also the hard costs, the cleanup costs, everything that the city has incurred, that's $5,800 something. That's also not subject to reduction. So you have those. I'm going to just do really rough math. That's about $36,000. That's going to be your base that you're going to have. On top of that, what you're asking me to reduce is this additional $1.15 million fine. And I'm looking very favorably on reducing that. Not really sure. I've never considered such a large reduction before. I don't want to affect the city's, budget there. I mean, was that is that something you were expecting to have cover some expenses for the city, or?
Yeah. Yes, sir. Again, that is a large amount of money, and we understand that. But the property's been vacant, has been vacant since we demolished the residence that's on it. The city would like to see a new structure, affordable housing put on the property. But with that, taking into consideration of everything, again, that would be up to Mr. DeSilva to make his offer and plead to you what he would feel would be appropriate, and then base it from there.
So given that 36,000 is already going to be, that's for everything else, that's for all the hard costs and everything. We don't have the authority today to reduce any of that.
Okay, just one.
But then
thing,
we
sir.
also have, like he said earlier, there's 9,800 still in surplus. So assuming the city of Titusville has highest priority on that, which I would assume that we do, that's going to be hopefully dispersed when the timeline comes up to the city to reduce the amounts that are owed on the property, okay? Again, I can't guarantee that, but that's the intent of that 9,800. Given that in mind, is there a dollar amount you would be comfortable paying in lieu of paying $1.15 million?
Sir, if the 36 gotta be paid no matter what, honestly, I will ask for a reduction for zero, because I already received a bill from the water of 111 that's going to be due today. So the lot's vacant, nothing's being used, and the bill is already 111. That's almost the same amount of the bill in my house, and I have 4 people living in it, So I don't want to question, but that's not going to stop. If you can have the reduction, probably I can deal with them, even if the amount is larger than I expected, but and I can move forward with the project. The thing is, now I don't want to just have the profit. I want to get this thing done properly, build the house. If the profit is not that great, okay, we're going to move to the next one and get the experience of this one.
Yeah. Yeah, I mean, regardless, the utility and the stormwater liens are going to cut into any profit margin you would have had anyway. But I don't feel like I can reduce the 1.1 million all the way down to zero. All right. Let's see, so that, all right. I have reviewed the lien reduction application in the city code provision that is applicable and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff and applicant. I will recommend that city council reduce this lien to, I'm going to say $5,000 based upon several factors as provided by the city code, including the gravity of the violation, the actions taken by applicant to correct, and the time it took to bring into compliance, which is actually irrelevant, sorry. The accrued amount of the enforcement lien compared to the market value, that's the big one. Any previous or subsequent code violations, your prior knowledge of the lien, and the other circumstances that you've discussed today. So what that means is for the lien, the fines itself would be $5,000 plus all of these other stuff that we talked about, which is the $28,000 for utility services, $2,000 for stormwater liens, and then $5,800 for costs. Officer Tolleson?
Yes, sir. And then that, that was held by
The tax
county
deed surplus, yeah.
does come in,
Yeah, that-
would we be able to reduce that number?
Yeah, do I need to state that in the order?
Yes, yes, sir, if
Okay.
you would, please.
All right.
Because that's not due until September the 5th, and
Right.
he would have 90 days from
Okay.
today. So, I mean, it would play into the same, but we would need the authority to reduce it by then.
Okay, any amounts that the city receives from the surplus from the tax deed auction will be a credit to, or be credited to the fine amounts and the lien amounts here,
Okay,
okay?
okay.
So again, just to be clear, the fine is $5,000. The city's costs are, I had it, 5,800, do you have the exact?
$5,874.87 for
Okay.
the code.
Right, so that's the city's costs. Then in addition, you'll still have the utility service of $28,177.39 and $2,000 and $2,072.55 for stormwater liens, okay?
Okay,
And again, any amount from the tax surplus, which approximately $9,800 would operate to reduce all of those amounts, okay?
okay,
You receive a written order from today's hearing, which will just be a recommendation to City Council. You'll have notice and opportunity to attend the City Council meeting where the recommendation will be considered. It is so ordered.
all
Thanks.
right. Thank you so much.
Yeah. Okay, I think that concludes all of the lien reduction hearings, so we can go ahead and move to our one Massey hearing that we have on the agenda, which is for 160 Park Lane in Titusville, Florida, 32780.
All right, sir. I have to present to you the notice of hearing and the cost affidavit for $216.58.
Go ahead.
Good. Again, this was 160 Park Lane. This is a Massey hearing. The mail to address is the same. It was for junk and debris. The notice of respondent was first class and certified in July 21st, and it was posted on the property in City Hall on July 28th. This case was originally heard on July 14th, and the respondent was not present. They were given until noon on August 8th, 2025 to correct the violation, if not a fine of $100 per day commencing on August 9th, and continuing until the violation is corrected, along with the administrative costs of $216.58 were imposed. As of today, no action or permits to correct the violation has been completed, and no contact has been made with the respondents. Let me go. These were the original pictures, just to refresh your memory. You have the junk and debris, the vehicle as well on there. This was the follow-up pictures back in June with the appliances and the junk cars in the driveway, and the debris as well. Same back in June. These are in July 28th. There's been no corrective actions to try to clear up the property at all. Now there's two vehicles on there that are inoperable as well, and they are present as there today as I went by. And again, no corrective action, and I don't believe anybody's here for that case either.
Did we check out in the hallway? Make sure no one's out there?
Yeah. Send the sergeant at arms.
All right. I find based on the evidence and testimony presented that notice was properly provided to the respondent and the respondent did not appear. The evidence demonstrates that the property located at, oops, I lost it again. 160 Park Lane, Titusville, Florida, 32780 remains in violation. Specifically, They are in violation of City Code Section 12.23 regarding junk and debris, and the property is not in compliance with the previous order dated July 18, 2025. Therefore, I find that the city has established a continuing violation of the aforesaid provision. Accordingly, a fine of $100 per day is imposed commencing, let's see, what day? August 9th, right? Yes, today's the, yeah, all right. Commencing on August 9th, 2025, and continuing daily until the violations are corrected. Additionally, the costs of $216.58 have not been paid and will be made part of the order. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. Thanks. Are all these gentlemen here for the same matter?
Yes, sir, they're here for,
Okay.
Early Bird.
Is there anyone else here waiting for a hearing? Or should I go ahead and take them to their?
We could go ahead and go with
Okay.
that next. Or
Let's go ahead and move to that one. That is 25-44. They've had to sit through all of these already, so let's get them up.
So I have 3 items to submit. The first one is going to be the affidavit and notice of violation. The second is going to be the affidavit and notice of hearing. And the third is the cost recovery statement in the amount of $146.14.
Thank you.
So once again, this is the initial hearing for case number 25-44. Our respondent is Richard Manzo. Our violation and mailing address is 2655 Alley Bird Drive in Titusville, Florida. We have 2 violations. First is section 28-365. That's the storage of shipping containers and vehicles on residential districts. And the second is 28-373B. It's the temporary storage units. So the initial inspection was completed June 9, 2025. A copy of the notice of violation was hand-delivered to the owner. They were given until June 19, 2025 to remove the container. Certified and first-class mail was sent on June 10th. Certified return receipt was returned unclaimed on June 30th. Notice of hearings were mailed out July 11, 2025. Certified copy of the letter has yet to be signed for or returned. So we received multiple complaints concerning a shipping container being placed on the Park Preserve HOA Track 2 behind 2655 Alley Bird Drive. I spoke with HOA board member Lori Jones, who stated on June 7th, a contractor delivered the shipping container to the subdivision and placed it on Track 2 without the board's consent. Review of building department records for properties along Alley Bird Drive. I found no temporary storage container permits issued. And a completion of the inspection found a 52-foot shipping container was placed on Track 2 behind 2655 Alley Bird Drive. So during my initial inspection on June 9th, I did speak with Richard Manzo, who confirmed his son had the container delivered over the weekend, and the plan was to move it into their backyard to be used for storage. He explained that it was his understanding of Florida state statutes that the right of homeowners to use shipping containers for storage purposes in the state of Florida was protected. We discussed the code sections that deal with shipping containers here in Titusville, and the prohibition for them being placed in residential zoning districts. and asked that the container be removed from the HOA property since they did not have permission for it to be there. I also advised the owner to speak with the Building and Planning Department with Titusville before moving the container onto their property so that they can discuss the city statutes and the state statutes. Like I said, a notice of the violation was hand-delivered, and I provided also contact information for the Building and Planning Departments. So, it was indicated in several conversations with the owner that him and his son had visited City Hall and spoke with the Building and Planning Department staff. Emails were provided to the Building Department staff with the Florida statutes and their understanding of them, and I do have a copy of that email if you need it. Email response from Building Department and Planning Department staff was sent to the owner on July 1st. Specifically from building official Steve Adams, he stated code section is stated clearly, myself nor any other member of city staff has the authority to override or exempt the adopted ordinances. Same thing with planning staff. Ms. Tabitha Armstrong stated, the Board of Adjustments is unable to authorize a variance for the use. The code statement that the placement or use of any shipping container as an accessory building, storage building, or living unit on residentially zoned land is prohibited. So on June 18, 2025, a reinspection was completed. The storage container had been removed from the HOA Track 2 and had been moved into the backyard of 2655 Alley Bird Drive. At the time of today's meeting, the shipping container remains in the backyard, and there has been no permit issued for the temporary placement. So I did include the two code sections, 28-365, 2, again, states that shipping containers used as an accessory building, storage building, or living unit on residentially zoned land used for residential purposes is prohibited. And then there's a lot in here, but 28-373, it does allow for the temporary placement, but there's some restrictions to that placement and its size, and a limit of 30 days for the unit to be on the property.
Without a permit?
With a permit.
With a permit, okay.
Yep. So, and that was written for the, when pods and similar storage units were becoming popular. So this is a inspection photo taken July 29, 2025, when I delivered the notice of hearing for today. So this is the shipping container in the backyard. So the conclusions of facts for this case, for 28-365, the shipping container remains on a residentially zoned piece of property. And for the temporary storage units, 28-373, the shipping container exceeds the maximum length allowed for temporary placement, and no permit has been issued allowing the container to stay on the property.
You said you had an email?
I have both the building departments and then the one from Richard Manzo concerning the state statutes.
Let me see both. Thank you. Thank you. All right. Okay. You can continue. All right.
So we are asking that the respondent be ordered to correct the violations on or before noon of September 5th, 2025 by removing the shipping container from the property. If the respondent does not comply by September 5th, we are requesting a fine of $50 per day per violation be imposed for each day the violation continues. We are also asking that the administrative costs in the amount of $146.14 be assessed. and they need to contact myself to confirm compliance.
Thank you. Give me 1 second. Let me work through this real quick. All right. Sir, what is your name?
Hi, my name is Richard Manzo as well, and good afternoon, Mr. Nguyen. Now, excuse me real quick. So, first, I'd like to thank you, for the opportunity to speak today, and I would like to first start off by saying that there is no violation on our part, and the city is in violation of state law and Florida Building Code, because we own a storage unit and a shed recognized as such by both Titusville and Brevard County, not a shipping container, as they allege. Now, Titusville's own definitions undermine its position because, as you heard, Titusville defines a storage unit as a transportable unit designed and primarily used for the storage of building materials, household goods, etc. And a shed is defined as a freestanding residential structure used for storage of items such as lawn equipment, washer, dryer, etc. So clearly our structure meets both the definitions and the city's contradictory labeling, calling it a shipping container in the prohibition, yet referring to the same structure as a storage unit elsewhere underscores that classification is based on use and not origin, and the Florida Building Code clarifies this. Florida Building Code Section 302.1 states classification of buildings and structures is based on occupancy and use. And it continues, occupancy classification is the formal designation of the primary purpose. So if we had the same structure built out of wood or aluminum, the city would recognize it and allow it as a shed. The only difference is that ours is made of a different material. And that is enforcement discriminatory, which state law forbids material-based discrimination. Statute 553.73 paren 4 paren B2 states that local amendments to the Florida Building Code must not discriminate against materials, products, or construction techniques of demonstrated capabilities. And statute 553.38 states that local building rules must be reasonable and uniformly applied regardless of whether a structure is conventionally constructed or manufactured. So it's pretty clear that the city's ban, based solely on material, which is steel, rather than a safety function, violates these core principles. Now, I also would like to talk about the public safety as well, because our shed far exceeds the Florida Building Code standards. So the city unjustly attempting to ban our shed is creating a public safety hazard in and of itself. Sheds such as ours, they are a much safer method to store your household items or possessions, because if any of us in this room had something that we wanted to store, keep safe, family things, memorabilia, any stuff like that, why would you not choose the safest and most secure method and also cost-effective method? Now, as I said, these storage units are made of steel, let in no leaks. And not only that, but they not only meet but exceed the Florida Building Code standards. Our shed can withstand winds of over 180 miles per hour, Category 5 hurricanes, which is well above the standard for Florida sheds at 150 miles per hour. In a state such as Florida, we experience the harshest of conditions between humidity, hurricanes, tropical storms, tornadoes, floods, etc. So sheds made out of plastic, vinyl, wood, and other weaker materials, they rot, degrade, and get destroyed in these conditions. And this is not only a public safety hazard to the homeowners, such as us, but also to the entire surrounding neighborhood, because each year sheds made out of these materials, they fly into the yards of people, they fly into houses, breaking windows, walls, cars, even risking and injuring the lives of people every year. Imagine being struck by a piece of wood, from a shed or the roof of a shed, flying at 80 miles per hour. So our shed is the most structurally sound and can comfortably withstand the harshest of elements, including Category 5 winds as stated, and provides much more safety and peace of mind. They are also inherently fire resistant, non-combustible, and impervious to termites, mold, and rodents. Most wooden sheds are highly flammable and degrade faster in Florida's humidities. Ours is also more durable and cost-effective than sheds half their size. Now, Brevard County also passed a law in 2019 allowing homeowners to use storage units such as ours. Numerous other Florida municipalities have also recognized the advantage that these have and have ruled against discriminatory actions. Such municipalities include, but are not limited to, St. Petersburg, Tampa, Lakeland, and many others. And I also have legal precedent supporting preemption and uniform enforcement. Orange County versus Sign 2019. The Florida Supreme Court affirmed that local ordinances cannot conflict with state law and must yield if inconsistent. Another case, Phantom of Brevard, Inc. versus Brevard County, 2007, went on to say that local governments may act in unpreempted areas but cannot conflict with state law. Case Zuccarelli III versus Barfield III, 2016, recognizes that selective enforcement, treating similarly placed parties differently, violates equal protection. In this case, the same structure is permitted under one label as a shed or storage unit and banned in another as a shipping container. So that is selective enforcement. Additionally, the case of Scurlock versus the City of Lynn Haven also supports the Florida Building Code's authority to preempt local ordinances if such ordinances are discriminatory of structures based on material and building methods used. And we also have a legal principle regarding vagueness and arbitrary enforcement. The case of, now I may be mispronouncing this one, but Papachristou versus the City of Jacksonville. The Supreme Court struck down a vague vagrancy law encouraging arbitrary enforcement. Here, Titusville's terminology of container versus shed fails to give clear guidance, leaving homeowners subject to unpredictable and unfair application of the law. Now, we've acted in good faith, and we have wanted to cooperate fully with the city, and we've been working with Agent May, and who's awesome, very helpful through this whole process, as well as Bradley Flack of the building department, who also has helped us a ton through this process, and he's the one who allowed us to move the shipping container into our yard and give us the time that we do now. So they've been great. Besides them, though, we do feel like the city of Titusville has let us down. We, as she mentioned, have tried to request a variance hearing, which legally we feel entitled to, as the state law does conflict with the local ordinances, but multiple times from multiple representatives we have been refused that due process. And we have committed, again, no violation. Our storage unit is legally recognized as a shed and a storage unit, not a shipping container. And the city's prohibition is discriminatory, use contradictory, material-based, and conflicts with the Florida Building Code and state statutes. This false allegation of a violation is reliant also on an unconstitutional amendment to the Florida Building Code, which we have no way of confirming was actually enacted properly. And at the end of the day, homeowners have the right to store the possessions in the most safest way possible because, as I said, we live in Florida, which is, not the most fairest of conditions weather-wise. And, and we shouldn't have to worry about selective or unreasonable enforcement from local ordinances. And the legal precedent that, I've displayed here today also affirms that such discriminatory or vague enforcement should not stand. And I would like to formally request to the city that they acknowledge that we are in no violation and that our structure is a legal storage unit and shed. I would also like for them, to eventually amend their ordinances to align with state law and Florida Building Code and allow us to continue using it as the state of Florida intended. Since installing it, we have not negatively impacted our community at all. And really, we've only created, higher safety through our whole entire neighborhood. There are other, neighbors in our area that have sheds made out of plastic and vinyl. And again, those pose much larger safety concerns if we get another hurricane or something like that. So, sorry for the long-winded.
Good.
But no, thank you for listening, and thank you for, your consideration.
Do you have the cases or anything that you're
Yeah.
excited?
Yep.
Obviously, I'm not going to have time to read them all today. I was looking through the ordinances. Oh, you don't have the actual cases printed? Okay, that's fine.
No, sorry, yeah. That one I just handed you, that is more, because since then, we've had a lot more time to go over, so that's a more refined copy. And also, if you'd like, I can give you a copy of what I just read as well, depending on
What are you currently using the structure for?
storage.
Storage?
Yep.
And so basically, you're saying it should not be defined as a shipping container? It should be defined otherwise?
Yes, yep.
I mean, it's difficult position you're not just put, all the officers and code enforcement officers in, because they don't write the ordinances or anything like that. Same with me. We're just looking at the ordinances, and we can't really say, oh, this is a conflict here, or advise to the city council to change an ordinance here or there. I was looking through the ordinance to see if there was a definition for what constituted a shipping container. There was a lot of information you gave me there. What argument did you have that it is not a shipping container? Is it because of the use of it?
Yeah, multiple. So the use of it, exactly that, the Florida Building Code states that the primary definition, the classification of a structure or building is through the intended use of it and not through the origin. So just like, you have people who renovate cars or renovate other things that it was a car, now it's a house, now it's a boat, now it's a whatever. So, things, it's classified by use. And the other as well is, in its current state, it is impossible to use as a shipping container. So it can't be used. It needs things and certain criteria that it simply doesn't have. And also across the entire state as well, like I said, people are using these storage units and sheds as legally it fits all the definitions squarely, and its intended use is for storage.
Right, but it's still a shipping container, right? I mean, that is what it is, right? It's repurposed shipping container, correct?
But legally is what I'm saying is that the Florida Building Code says that
And-
it cannot discriminate based on the origin of it.
But I'm not, and again, I'm not trying to be argumentative. I'm just saying, as far as the Florida Building Code goes, I'm not an authority on that. so to
No, I
speak, right?
understand, yeah.
I'm looking strictly at our ordinances, and, it is a black and white prohibition, especially when you're talking about a shipping container on residential property,
Something too that, we talked about as well with the city, as well with Bradley Flack as well, is, we want to act in good faith, because really, at the end of the day, all we want to do is just be able to store our stuff in the safest way possible, in the, most cost-effective way possible. And so we are, more than comfortable with making, visual modifications if, it would make the city more comfortable to, resemble certain types of sheds or such, But again, we just feel confident that, and we tried to get a variance hearing, because that's, kind of exactly what you're saying is that,
Right. The code says what it says, right? Like, I don't think there's any wiggle room for me to accept the definition of it as classified as something other than a shipping container. So I'm literally just looking at what the code says as far as non-conforming structures. But it's not being used as a residential structure?
No.
It's just, I don't, let me see. You cited a lot of cases.
No, I
I
apologize.
don't know anything about. I'm not so much sold on the argument that the use of it makes it not a shipping container, because no one that places a shipping container onto their house is using it for shipping. Like, that by your argument, that renders the entire city ordinance moot. I don't know about like the conflict or purported conflict between the Florida Building Code and Titusville ordinance. I honestly don't know anything about that. I don't know if the city has anything to add about, purported conflicts with the Florida Building Code, or if there's any position that you guys have taken in the past with regard to that.
I instructed the owners to go to Steve Adams, the building official, because he would be the ultimate, to make a determination since he administers the building code. And he referred it back to the prohibition under the 28, the code's not in my head.
365?
365 with the prohibition. I can't make that determination between state law. The building official
Yeah.
would be ultimately over the building code to make those determinations.
And is this the same individual that he would have to request a variance from?
The variance is administrated through the planning department. And again, planning staff came back after reviewing the ordinances and descriptions stating that they wouldn't be able to do a variance for the use.
Yeah. Is this intended to be a permanent structure?
Well, what we spoke about as well when I talked to Bradley Flack, because Bradley is also one of the heads of the building department, correct?
He does, he's a building inspector and
building
does plan
inspector, okay,
review.
yep. So, yeah, because I was trying to speak with Steve Adams, but I ended up speaking to him. And what he told me is, he asked, well, if it's a permanent structure, or maybe if it's temporary, and we spoke about 3 years possibly for having it on the property. So something to that effect possibly.
The codes are very clear on anything above 110 square feet, a permit is required, be it made out of stick matches or out of a shipping container. So it would have to have a permit regardless. And no permit, no variance. No denial of a permit, there's no variance. Our zoning codes are very clear. It's not allowed. And until that changes, our zoning codes would run in favor of the city, which says that shipping container is not allowed on the property at this time.
Mr. Manzo, what was your, had you gone through the process of submitting for a permit, or you're taking the position that a permit should not be required, period?
Yes, to that effect, because to me, it also doesn't really make sense if we were to apply for a permit, as you said, to get a variance. We need a permit, but if they're saying we can't get a permit, but our position is that the state doesn't require it, the state allows us to have it. So, how we can't really get a variance if they won't let us get a permit as well.
I just don't think that I have any vested authority in me to deviate from what the code says. I'm not making any representations as to, a lot of the stuff that you brought up, and I'm sure you have other avenues. I see you are an attorney as well, so I'm sure you're fully aware of what your options may be. I just don't think I can deviate from the black and white language of the code, and I appreciate your thoroughness. Quite frankly, I do, and I wish this was something I can dive in deeper in and actually do, a full-on memoranda on. But that's probably not what they're paying me to do up here. It's just to see whether or not a violation of the ordinance exists.
Is it possible to have like a continuance or something to that effect done on this?
Right now, the city has asked for the violation to be corrected by September 5th. It's up to the city if they don't mind pushing that back a little bit more time for you to explore the permitting option, the variance option. I know that the adjustment board has already said no, but I don't really know if that changes after this hearing or not. I don't know if you guys would be willing for 60 days, I'm sorry, or anything like that, just to give them additional time, but
What kind of time are you looking at?
Well, the time just to, be able to sit with, because I've tried to sit with Steve Adams and meet with him, and I haven't had the opportunity to. So, time for that and time to, just prepare that way. Maybe we can see about having a variance hearing on the matter,
Well, again, the variance would have came into play had they denied your building permit. That would have been the variance, would have gone after that.
I understand, yes,
But with that being said, till the meeting in October, would that be fine?
yeah, I think that would, yeah.
But again, though, it also should be noted that there are HOA deed restrictions in play at this, so I'm not sure how they're going to feel about the additional time.
right, well, I mean, they have their
Us,
own, yeah,
We would be,
yeah.
and I just wanted that on record, that we would support till October for those meetings to happen.
I represent HOAs all the time, and I always tell them, if you're expecting code enforcement to act quicker than the HOA can, then you're not. That's really on the HOA to move forward at their own pace, and they should understand that,
Yes, well,
government
I've
is, yeah.
explained that. Yes,
All right. So basically, I'm going to say, again, all I can do is there a shipping container on whatever the use is? That's not my charge, everything
No,
like
I
that,
understand your
right?
position, yes.
So I have to say that it's still there. I mean, the evidence shows that it's there on the property. We're going to push back the time for you to explore your options, everything like you said. If looking for a permit, trying to get that conversation with Steve is the best way to do so. And then whatever comes from that, you have 2 months almost to kind of figure that out before we come back here, before any penalties start to accrue. And again, this, what you're trying to bring up is much larger issues that go beyond anyone here. And so maybe when you talk to Steve or whatever, that does go up the ladder some, but did you?
Yeah, yes, sir. I was just going to make note that would move the Massey hearing till the October 13th meeting.
And that's fine with me, yeah, okay. All right. Okay, so I've reviewed the lien, no, sorry, wrong one, lien reduction. Yeah, I'm just repeating myself every time. All right. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Richard Manzo is the owner of the property with the address 2655 Alley Bird Drive, Titusville, Florida, 32780. I find that all required notices were provided in accordance with Chapter 163, Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of Sections 28-365 and 28-373, subsection B, which are regarding storage of shipping containers and temporary storage units, exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but either failed or refused to do so. The corrective actions for these violations shall be either to remove the shipping container or, as we say, get a permit or a variance to allow it to be there. Additionally, I find that the city has incurred costs in the amount of $146.14. Such amounts shall be included with this order. Respondent shall be given until October 8th. Is that correct?
13th?
Or 13th is the hearing. So 8th.
Yes, sir. The meeting
8th is
would be on the 13th, so 8 would be the Friday before, yes, sir.
Okay. So Friday, October 8th, to correct the violations. Respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by October 8th,
Friday would be the 10th.
I'm sorry, okay,
8th would be a Wednesday.
okay.
That's correct.
So should we move it to the compliance date of October 10th then? All right, sorry. Respondent should be given until October 10th. All right. If respondent fails to correct the violation by October 10th, a fine will be entered in the amount of $50 per day per violation, which is 2 violations, so $100 per day, until the violation comes into compliance. Further and future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right. Thank you.
Yep, thank you. Thank you for your time.
Yeah.
Thank you.
Did you provide a handout?
He gave me just, these are like the statutes that he's citing to in cases, but, where are you licensed, Mr. Manso?
Actually, so I was going to say, sorry, I don't want to cut you
No,
off, but
you're
it's actually my father who's the licensed attorney.
Okay, gotcha.
the legal assistant, though, with the office.
Okay, gotcha. All right. There's another attorney we work with a lot in Orlando named Isaac Manzo. Any relation or?
No, but you know, I get his mail, I got a check sent me, he
Okay.
does a lot of real estate.
Yeah, he does. We refer work between each other, so.
And,
yeah.
I've gotten calls, mails, even
a good guy.
checks sent them back.
All right, all right. Well, if you're ever looking for a job at Manzo and Associates, let me know. I can.
All right, sounds
Hook
good.
you up
I'll
with-
fit right in.
Thank you,
No,
sir.
hey, thank you so much.
All right.
Thank you.
All right.
Okay.
You guys made it a difficult day today. All right, we still have 2 more initial hearings. We'll get back on the agenda. It's 25-36, 419 Wager Avenue.
Yes, sir. Notice of violation, notice of hearing affidavit, and the cost reimbursement of $251.80 for you, sir. Good. Again, this is 419 Wagger Avenue. The mail-to address on file was 975 Nova Terrace. Was for junk and debris, 1223, IPMC 302.7 accessory structures for the fence, and 304.7 for roof and drainage. Notice was posted on the property in April 7th. It was given till April 27th. It was mailed on April 7th, first class and certified. For the hearing notice, it was mailed on July 8th, certified in first class, and it was posted on the property in City Hall on July 28th. On April 7th, 2025, I observed several violations. During proactive checks of the area, observed debris in the front yard and the side of the house, fence sections falling and missing, and sections throughout the property, and the roof needing repair. It had a tarp on the one section of the roof. No contact has been made with the property owner. No corrective actions have been made. These are the original pictures back in April. You can see the fence is falling on the side. That'd be the left side of the house. This is the right side of the house. More debris in the fence sections that's missing. And that section over the door there is also where the roof is damaged and has a tarp on top. This is just another picture. This was back in July 28th when I posted the property. The fence still not in repair and in debris, with the debris in the front yard as well. And it's kind of a picture. You can see the tarp on the roof on the side there indicating it does need to be fixed and repaired. This was previously brought up before with the roof damage, but it had not been taken care of. And there's still debris in the yard. And you got the wheelbarrow with different debris items and things, and the fence falling, etc. Just close up of the wheelbarrow. And that's the property notice. Sorry, the conclusion of facts, the junk and debris of outdoor storage and debris items in the front and side yard. The accessory structure for the fence sections are falling and damaged in several sections on the property. And the roof and drainage, the roof has a tarp on the side of the property. It's not properly covered, not considered a proper roof. The recommendation, remove all junk and debris from the property or store it inside. Repair or remove all damaged sections of the fence and the roof and drainage. Remove the tarp from the roof and make the proper repairs as required and obtain a permit as needed. And order to respondent be assessed the administrative cost of $251. Respondent does not comply with the violations by September 5th. We are requesting a fine of $100 per day for each violation until the violations are all corrected, and to contact me for reinspection.
Thank you. All right, I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondents Eric Hampton and Catherine Jefferson are the owners of the property with the address 419 Wager Avenue, Titusville, Florida, 32796. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that the following violations of city code exist upon the property. Sections 12-23 regarding junk and debris, section 6-109 regarding accessory structures, IPMC section 302.7, and then IPMC section 304-7 regarding roof and drainage. Exists upon the property, and respondents were given a reasonable amount of time to correct the violations, but either failed or refused to do so. The corrective actions for these violations shall be to remove all junk and debris from the property, repair, remove the damaged fence sections, and remove the tarp from the roof and make the proper roof repairs. Additionally, I find that the city has incurred costs in the amount of $251.80. Such amounts shall be included with this order. Respondent shall be given until September 5th, correct? To correct the violations, respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by September 5th, a fine will be entered in the amount of $100 per day per violation, or is $100 per day for each violation until the violations come into compliance. Further, and future violations of the same sections shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right, moving on to our last one for the day. Officer Lewis, I don't know if I've
No,
had you
sir,
present to
we've
me
not met
before.
yet.
Oh, man, I'm excited. All right. All types of unique ones today.
Okay,
All right.
first I'd like to enter in as evidence the affidavit for the notice of hearing and our notice of violation and the cost summary, cost recovery statement.
Thank you, sir.
Okay, again, this is case 2537, initial hearing for property at 3700 Miriam Drive. Respondent is a Jessica Cassell. We mailed the notice to 3655 Valley Forks Drive here in Titusville, which is the address in the Brevard County Property Appraiser's Office. All the mail came back, is unclaimed, unsigned for. Violations are 1223 junk and debris, 6109 2018 IPMC subsection 302.4 overgrowth and weeds, section 303.2 enclosures, swimming pools, and section 303.1 swimming pools. The initial inspection was on 6/24/25. Date given to comply was July the 3rd, 2025. Certified and first class were sent to the listed owner on 6/25/25. Certified mail was returned unmoved, no forwarding 7/7/25. The notice of hearing was posted at City Hall and on the property where the violation exists on 7/16/25. Certified mail and first class mail were mailed on 7/10/25. Certified mail sent to the listed owner was returned unclaimed, unable to forward on 6/4/24. This house has been vacant for some time. An inspection was completed in response to a complaint received about a vacant residential structure with an unsanitary pool. The inspection found a pool containing stagnant discolored water and an unsecured pool enclosure. The enclosure is damaged and unable to be secured to prevent access to the pool area. There is not a fence on the property either, on the property at all. There's overgrowth on the property with junk and debris scattered throughout. The property was posted with a notice of violation. We did have some contact with the owner. We were able to find a number for her through another document. She is a realtor, and she stated that she is not going to do anything with the property, that she is going to sell it.
And then the new owner is going to say, I didn't know.
Yep. To date, none of the violations have been corrected. There's the code for junk and debris. Code for the overgrowth, which is over 12 inches in several areas of the property. The enclosures in the swimming pool, like I said, that the enclosure, if you don't have a fence, is supposed to be self-latching and locking. It is not. The enclosure itself is damaged to the extent where you can just pretty much walk through it at several spots. And the swimming pool has several feet of very dark water, as you'll see in the pictures coming up. There's some overgrowth on the side. This is the side here that actually faces Carpenter Road. Property's at the corner of Miriam Drive and Carpenter Road, South Carpenter. And it went away. Okay, here's the pool enclosure right here. As you can see, it's a little bit hard to see, but the door is ajar. It cannot be secured. Most of the screen is missing in the enclosure. That's some of the junk around it. You can see there that the screen is missing in the enclosure. And we're gone again. I don't know where the rest of my pictures went. But the conclusions and the facts in the case is there's still junk and debris on the property. There's still overgrowth. The enclosure has not been repaired, and the pool still has several feet of very nasty, dirty water in it.
We good?
I thought it's very hard to see, but if you'll look to the right side of the picture, right
I
above
see
that
it,
crossbar
yeah.
back there, that's where the pool is.
I see how gross it is. I wouldn't swim in there. Any reason you're asking for $150 per day as opposed to $100 per day?
This structure has been vacant for several years, and it's
Okay.
just been, I mean, I've had to write it several times. How she came upon it, I do not know. But like I said, I contacted her hoping something would happen, and she pretty much said, I ain't doing anything, so.
Sounds like a realtor. Okay, all right. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Jessica Cassell is the owner of the property with the address 3700 Merriam Drive, Titusville, Florida, 32796. Sorry. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on evidence presented, I find that the following violations exist upon the property. Section 12-23, junk and debris. Section 6-109, 2018 IPMC subsections 302.4, overgrowth and weeds. Subsection 303.2, regarding swimming pool enclosures, and subsection 303.1 regarding swimming pools. Respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective actions for these violations shall be to remove all junk and debris from the property, mow and trim, remove all weeds and grass over 12 inches, repair the screen enclosure and the door enclosure to prevent unauthorized access to the pool, and to return the pool water to a sanitary condition. Additionally, I find that the city has incurred costs in the amount of $128.53. Such amounts shall be included with this order. Respondents shall be given until September 5th, 2025 to correct the violations. Respondents shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by September 5th, 2025, a fine will be entered in the amount of $150 per day per violation until the violations come into compliance. Further, in future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right. Thank you. Going back to our agenda, I think the only thing left we have is the code enforcement manager's report.
No report this month, sir.
All right. Then I think we are adjourned here at 3:39 p.m. Thank you.